Hello, I'm Guido Calabresi, and I'm interviewing Chief Justice Ellen Peters for the Connecticut Bar Foundation project. Ellen, where were you born and when?
I was born in Berlin, in Germany, in 1930, at a time when the Holocaust was still far away. Of course, it turned out not to be so far away a little later on.
When did you come to America?
My mother and my sister and I came in December of 1939. My father's visa still had not come, and so he joined us a good deal later. Our great relief, he made it.
He made it in 1940.
He made it in 1940, having still been in the Netherlands when the Germans were marching in, and managed to bribe himself on a plane that was taking mail to Spain.
He came in a plane?
To Spain, and then across country and wherever he could find a place to move closer to this country. He finally ended up in Mexico City waiting for the visa.
To come into the United States?
Yes.
But he was in Mexico City while you were here, and you knew that he was safe in Mexico City, at least at that point.
We did at that point. When he first wired us from the little town where he had landed on the mail plane, we hadn't a clue where that was. And my mother and my sister and I pored over an atlas trying to figure out, because in his own nervousness about a very precarious situation, he hadn't been particularly specific about identifying where he'd landed.
And where were you at the time in the United States? You were here, but where, in New York? Or?
Yes, I spent most of my time before I went off to college in a lovely apartment on Riverside Drive in Manhattan.
Now, how did you happen to be able to come to New York? Did you have relatives, or did you have friends? Or?
We had some friends and some relatives. But my father has, as the plain story would indicate, was always very entrepreneurial. So for numbers of years he had taken commissions payable in this country in dollars, so there were some dollars for us. Not a lot. My mother saved every penny that she could save so that we could live on that amount of money. I don't know what the fund was.
So you did have some funds in the United States when you arrived?
We had some resources.
I know all too well the difference, because we did not.
Yes.
You had one sister.
Yes.
And is she still alive?
I know, my sister died 50 years ago.
Oh.
When she was pregnant with her first child.
Oh, dear.
It's pretty awful.
And did the child live?
She survived, and we're, of course, on good terms, and this summer we're going to a family reunion to celebrate her 50th birthday, my sister's husband's 80th birthday, and all the rest of that family.
And all the rest of the family. What did your parents do? My
father was a lawyer in Germany, as had been his father. My mother was mostly a housewife. She had had a job as a secretary before she got married, but her real avocation was music. She played the violin for an amateur extraordinarily well, and that was a great pleasure in her life.
Did you and your sister play any musical instrument, or was that...
My sister Renata never did. I played the violin badly, but well enough to get along, mostly in the second violin section in the back seat, in which one's main endeavor is not to get the bowing wrong. Nobody will ever notice anything else. But it gave me great pleasure. I played in New York City, all city symphony, and then I played a lot at college, and when I got to law school, I joined, there was a professional and something or other group downtown, and I continued to play in that. Everybody needs a second violin.
There was a professional orchestra in New Haven at the time.
This was not the professional one. This was just of professional people.
No, but that's what I meant, of professional people who played for the fun of it.
That's right. Yeah. That must have been the group. And they were very accommodating, and I had a wonderful time, and I enjoyed it thoroughly. But then...
So that you took up both of your parents' interests, violin as a hobby, but you were talking about law all the time that you were growing up.
That's right. And I knew very keenly from my father, who was not able to resume that profession in this country, how keenly he missed it.
What did he do in this country?
Well, when I was older, I teased him that he was practicing law without a license. But formally, what he did was he was something called a registered investment advisor, and he was a junior partner in the stock exchange seat.
And it was so often the case with people who had a profession like law, like those who had medicine were able to pass exams and practice, but it was very difficult for people in law. So that he did something which was related to law as near as he could.
That's right.
Yeah.
I mean, that's another aspect of his entrepreneurial side. And he managed to make the best of whatever situation he confronted,
Now,
being very imaginative about it.
how did your mother and father live to an old age or not, or did they?
My mother died of breast cancer when she was 50. My father lived to be 91, and we married for the third time. My mother was his second wife, and lived happily and contentedly, and managed to have an office that he went to till he was in his late 80s. And I've often thought having a place to go to, which is not home, which is stimulating and gets you into a conversational mode, is what kept him alive.
But he lived long enough to see you really reach great success in his profession, because I'm sure he viewed it as his profession.
Well, of course. He did write me when I was first, I think it was when I was first a judge, that he was not sure that I was old enough to do it. A very warm and engaged father. I mean, he was always there for me in a lot of different ways. I was very grateful to him.
What neighborhood did you grow up in? You stayed on Riverside Drive
Yeah, I didn't go to school there after the first few years. I went to Hunter College High School, which was an all-girls high school in New York. Entrance by competitive examination. A wonderful school for me. I happened into it by accident. My parents heard somehow from someone that there was this institution, and I applied and was accepted. It was at that point all girls. For me, trying to become accustomed to the mores of a new country, it was really absolutely the right place to be.
There was a protection and a stimulation, so that you had to deal with certain things, but there were some things that you didn't yet have to deal with.
That's right, and I would certainly have been unprepared.
Did you do any part-time work when you were in high school, or?
Jobs for women or high school girls were not plentiful, and I don't think my parents would have approved of I had gotten a job at McDonald's or whatever the functional equivalent then was. But in my father's office, there was always a secretary on vacation. So I became the fill-in secretary, learned how to type, an asset which has been of great value ever since.
But in a real sense, it sounds as though you grew up in a household that remained very European.
Yes.
In attitude, when you said no to McDonald's, again, I know that there were some things which we simply didn't. We knew that we didn't do. That we.
I would not have had to ask to be sure that was not something appropriate. My mother struggled as it was with some of the high school things that went on that she was uncomfortable about. But at the end of the day, when we talked about it, she never stood in my way, but I think I had internalized their values sufficiently that I was really nothing terribly outrageous that I did as a teenager.
Did you think of yourself as primarily an American when you were in high school, or did you think of yourself still as a European?
That's a good question. My aim in life during the junior high and high school years was not to be confused every day about what was happening. And over the years, my confusion diminished. But there were still linguistic phrases which mystified me for a long time, particularly linguistic shortcuts that were not easy to unravel. I wanted very much to be like everybody else. It is not necessarily the best aspiration for a teenager, but I think when you have been through what I went through, it was certainly a very good second best.
Those were the years when I was known as Guy during high school. The
I
only time
remember
in
that
my
from,
life.
from law school days.
Some of my friends from high school called me that because
Yes.
of that same. Did you speak English when you came to America?
Literally no, but in Berlin in the last years, I had gone to the American school, which was taught in English, which was principally for American diplomatic children, other people who were Americans who happened to be working in Berlin. And so I didn't study, I just spoke English in that setting without anybody having formally taught me. In fact, one of my great joys was when I was beginning to read, and I finally discovered I could read German script and read German stories, which at that point I was much more eager to do. We then went to the Netherlands, and I learned Dutch and forgot English.
I see.
And so when we came back here, the public school classroom early in January of 1940 was a Tower of Babel. But nonetheless, having had the background, I think I regained my English much more quickly than if I hadn't had that blessing, as it turned out.
Was your family at all religious? Were you, or were you conscious of a tradition, or was that something that had kind of come up surprisedly when Hitler and?
We were, in my immediate family, totally agnostic. My father thought of himself, although he was Jewish, as an assimilated German, fought in World War I for Germany, was honored with the Iron Cross, and that's what made it so difficult for him to help us to get out in time. And we only did get out because early in September of 1938, he and my mother were arrested, kept in jail overnight, and friends got them out, but the message was clear, they could not get them out twice. So the assimilation was in many ways a handicap to hearing what was really happening.
Yes, yes. How did you happen to choose Swarthmore? A Quaker coeducational college.
Irrationally. My father had clients in Brazil. The clients in Brazil had two sons who were at Swarthmore and were having a wonderful time. So I applied to Barnard because I thought I had to have some place in New York, and I applied to Swarthmore. And I was rejected by Barnard, even though I was first in my class, in my high school class. And ended up absolutely thrilled to have been accepted at Swarthmore and to have had a glorious 4 years.
Has Barnard ever realized what they missed?
I'm not about to tell them, and I don't think anybody else is about to either.
And you went to Swarthmore, how old were you?
17, I guess.
So really very young. And was this your first time away from home?
Yes, it was, except for weekends with the family away, but by myself, yes. And I remember my sister, who was then still alive, saying, "Go. You need to get out of town. You need to find an independence that you won't have if you stay in New York."
And Swarthmore, what was it like for you?
Swarthmore was a place for a lot of people, a lot like me. We were very smart, and we were incredibly immature. We had pretty good work habits. We were perfectly willing to sit down at night and do 2 hours of homework for each class, and that was expected, and that wasn't hard. But to develop meaningful relationships with other people was, for me and for, I think, many of us, a work in progress. So that by my senior year, when I'd absorbed many of those lessons, I had a lot more friends, male and female, some of whom were dates, some of whom were just friends. And I think that growth in our social dimension was in many ways as important, at least to me, as the fact that the intellectual stimulation was wonderful, endlessly provocative and exciting.
What did you major in? What did you study?
Swarthmore has something called an honors program, which is still there, but much diluted. When I was there, this was for the third and fourth year, you had to take 8 seminars. You did nothing but the 8 seminars. Seminars met once a week at the faculty homes with tea and cookies, of all things. So my major was, I had a triple major. I did political science, and I did economics, and I did math. So I had 2 seminars of math and 3 each of economics and political science. And the seminars were essentially very excellent preparation for graduate school. We got a reading list that you could in no way could get through. So one of the agendas was to learn how to explore in a library, to see what really fit the paper you were writing, to get enough of an overview to understand other people's papers, produced a paper every other week.
Good.
With carbons.
So that your writing came easily and early in a way.
Well, it was a struggle at the beginning.
The struggle began early. But
yeah, but it was such wonderful training in putting one's thought to paper and being as analytically accurate as the professor could make us be. And I had a political science professor who really was incredibly good, named J. Roland Pennock, now deceased, although I still correspond with his widow. And he had a knack of taking young people who were bright but unfocused, really,
yeah.
and waking them up to the excitement of the mind and the intellect. He just did it so gently, but so insistently. We all grew up in his classes. It was great.
Wonderful. Did you know right from the beginning that you were heading towards law school, or was this one of those?
I knew that in high school.
You knew that in high school. This was.
My mother was very strong in some things, and one of the things she was very strong about when we came to this country was to tell my sister and to tell me that this was the new country and everybody had to be able to look after himself or herself. It was essential that we get training and that we get a job that would sustain us for life. My sister became a registered nurse, which she absolutely adored and was wonderful at. And I remember very well, I was about 13 or 14, a conversation on walking along the beach with my mother, and her saying to me essentially, well, now is the time to start thinking and start planning and to build the foundation for whatever it is you want to do.
Yeah. There's something about being refugees that made one be very aware that one had to do things of that sort.
That's right.
My dad said to me, about the same age, that he hoped that he would be able to put us through college, and if he survived and everything was fine, it would be. My mother was teaching, but we had to be able to do it ourselves because there was no backup. And that was, did you feel that sense that you had to make it because there was no family except your immediate family behind you?
I think in my case, it was more that I had no brother, and this was the line of lawyers from which I was descended. And my father, by that time, had at least established a financial footing. Not that we were well off, but we were not in jeopardy anymore. And so really the question was, what would I do really to make my family proud of me?
Yes.
And I think that, too, is the culture which you and I grew up in.
Did you know, or did your parents know that at that time in the United States, as against Europe actually, it was very unusual for women to be lawyers?
No. I've always thought that was a great advantage of being an immigrant child.
Yes.
Sometimes not knowing is a great asset.
Yes.
I think my father, as I grew up in the law, put it that way, became more aware of this, and I think that was part of his astonishment that I should get a judgeship, not to speak of a state judgeship. But they too were busy trying to fit into a new country and a new life. And of course for us there was never a question of going back home. I mean, not in anybody's mind ever to want to go back. I have not been back.
Yeah.
I have a cousin who's been back several times. And my feeling is if that feels good to her, that's great. Doesn't feel right to me, so I won't go.
And were there any particular extracurricular activities or things that you did in Swarthmore to shape yourself for law, or were you thinking essentially that work was the way to the classes?
I ran into a friend a few years ago who said, and I have no reason to doubt him, that he and I were together in a seminar called Argument. My dim recollection is the seminar, I gave you a problem and maybe an hour to think about putting together an argument. And that was lots of fun. And of course I took all the law courses that were being given, which ended up being one sophomore course and one senior seminar. I guess I was 80% persuaded that it was going to work for me. But I'm risk averse because of my childhood. And so the alternate road that I was going to explore if law school didn't work out was law and economics.
Economics?
I thought the economics stuff we had at college was intriguing. The trouble with my math was that when I hit advanced calculus, I discovered that I was not going to be a mathematician. Could struggle through, but without any real either joy or profound understanding about what I was doing. And that in a seminar can be a little embarrassing. But nonetheless, it was useful. When I thought I knew enough mathematics and could absorb enough, even though I wasn't going to do higher mathematics, I could probably do law and economics. I could do the basic curves and the tangents and all the rest of that.
Did you have various friends who were going to law school as well, or were?
I was very lucky in that respect. Two of my male friends from Swarthmore came to law school at Yale at the same time I did. That was a great asset in the sense that without an entree, the women were quite isolated.
Yeah. Let's turn to you. Did you apply to Yale and to other schools, or?
I applied to Yale and to Harvard. And I think I had a fallback in Syracuse, but it's so strange to me now that I would have thought that was a good place to go that I'm unclear. Bob Peters and I, at that point, were not married and we were not formally engaged, but we were certainly thinking about the possibility of being engaged. He, of course, in my same class at Swarthmore and going on to medical school, and he was accepted at Yale but not at Harvard, so it seemed natural to go to Yale. And also, I was really very, very well advised by my mentor at Swarthmore, J. Roland Pennick, who said, "You will be much happier at Yale. You will find it a much more fulfilling experience." So everything drove us to Yale.
And at Harvard, you would have been in just about the first second class that admitted women.
That's right. And I suppose I could have fought the good fight, but why spend one's energy on that when there was a profession that I wanted to explore without additional barriers?
And so 3 of you from Swarthmore came to Yale. That was quite a large number for at the Yale Law School from any one school. I mean, Yale and Harvard.
Admissions at that point were not as competitive as they are now. And there was not the horde of young people applying to go to law school anywhere. So that it's perfectly clear to me that my LSAT scores, and despite my reasonably good grades at college, probably would have put me on the waiting list. And
we all think that today.
Well, but I think that was equally true of the 3 of us. We had Dan Singer has gone on to a distinguished career in Washington, and my other friend unfortunately died in an airplane accident.
How many women were in your class at Yale?
We were 11, and we were only that giant number because it was the year of the Korean War. And there was great concern, as I learned in the admissions office, that there might not be enough men to take all the seats. because they would be drafted. They were, of course, not drafted. And so we had the largest class ever in the Yale Law School. We had 200 plus.
Oh, really? Because they weren't drafted for the Korean War, and
That's
they were
right.
taken.
So I can see admissions, taking a risk, it seemed better to take a risk to have an overpopulated class than an underpopulated class.
Yeah. And did you enjoy law school?
It turned out to be J. Roland Pennick every day. It was delightful. I had a very happy group of first-term teachers.
Who were your first-term teachers?
Fritz Kessler, who was absolutely wonderful. Even though he called on me on the first class and said to me, "So, Miss Ash, and what is a contract?" And it would have been inappropriate to say that's what I'm here to learn, but still, all the questions seemed to me not quite on target for what I was able to answer. But he was a wonderful teacher and had a wonderful way with the Socratic method, which I've tried to emulate when I was a teacher, which was to be enormously welcoming even of ideas that were pretty far off the mark, and then to transform them into something which sometimes the speaker didn't quite appreciate or understand, but then to use it as a base for going on. So I never heard him be cross with anybody, and that was really very nice to see. And I had J.W. Moore for procedure. It was very straightforward. It was stuff that was clear I had to learn. It was not as intellectually exciting as some of the other courses, but it was fine. Was McDougall for property.
He was still teaching property.
Oh, yes. No longer by your time.
Yeah.
He was teaching property, and I well recall going to the bulletin board, getting the first assignment, which was his first chapter of his book on property, whatever, and it was 75 pages long. No, it was more than, it was 150 pages long. So I said to myself, long assignment, but you've done longer assignments than this in the last couple of years. So of course I read it. Didn't take it all in, but I at least got an overview, and it started with great insight, I thought, with land use planning. That wasn't the title that was fashionable then, but that's what he started with.
Yeah.
And then eased his way into some of the more historical aspects of property law. He certainly had his own way of thinking, but I think people have not given him credit enough for understanding that he was perfectly tolerant and indeed encouraging for people to reply to him in ways that were not within his
scheme,
his outline of organizing the universe. So I enjoyed him enormously because these were such interesting ideas he was throwing out. And
who was your torts teacher?
Jimmy James.
Oh my! So you had James, Kessler, Moore, and McDougall, four towering figures, and you couldn't imagine four people more different from each other.
That's right. And each had a lot to teach, and each was so engrossed in the job of teaching. And I think, at least when I went to Yale, it was really a teaching school as well as a scholarly school. Mm-hmm. And people took great pleasure in their teaching. The constitutional law was perhaps the weakest of them. Well, that was John Frank, who probably had left the faculty by the time you joined it.
Mm-hmm. And what was the reaction of male classmates to women law students at Yale Law School at that time?
They didn't bother us as long as we didn't bother them.
Mm-hmm.
And that's why my two Swarthmore fellow students were such a great comfort, because they gave me an entree into things that were happening in the dorms, into some of the study groups, into some of the social life of playing bridge or whatever. Without that, it would have been a very lonely experience. Of course, the women lived off campus. We lived at the predecessor to 17 Hill House, which was had been a fraternity that had been condemned because it was a fire hazard, and then was deemed to be good enough for the women.
Just women at the law school, or women graduate
women,
students?
there were not enough women in the law school to
No.
fill up a dorm. That was, I thought, an asset. It was very nice not to do law morning, noon, and night. And we so next door to me was somebody who was studying art. Down the hall was somebody studying history. They were all graduate women in the various, because as you know, at that time Yale didn't have any women undergraduates. So in many ways I thought that's a model that Yale ought to think about again sometime. And by choice, not by necessity.
When you say a model, you don't mean women living by themselves, but law students living with graduate students.
Absolutely right.
Yeah.
Absolutely right.
Have you ever gone and looked at the fountain, the women's fountain at Yale, and seen the numbers and kind of traced where you were in those numbers?
I haven't looked at it that closely. I've seen it. I want to do that.
I've gone and seen where my mother was as a graduate student and her year, and I said, okay, that's fair.
Well, certainly when I joined the faculty, there were very few women faculty either.
Yeah. Now, as to your teachers, how did they react to you as a woman student?
I never encountered a moment of bias or trouble or harassment or anything other than being treated like everybody else, with one exception. And that was that my maiden name was Ash, and it was very easy to find on the seating list. So I think, particularly in large class, if you have to find somebody to call on, and there's a name early in the alphabet, that caused me to be called on perhaps more often than otherwise. But that had nothing to do with gender.
A perfectly neutral way of...
That's right. And because at Swarthmore I had been so fully engaged in my education, I was perfectly comfortable with participating. I knew I would be wrong sometimes, but it didn't strike me as unpleasant as it struck many of my women colleagues. When I first arrived at the law school, a woman in class ahead of me said, "Now the first thing you have to learn is never volunteer."
Really?
And so I said to myself, well, I'm glad it worked for you. I don't think that's going to work for me. So from a faculty point of view, it was a wonderful experience, entirely fulfilling. There was no problem whatsoever.
So that the stories that one hears, especially at the Harvard Law School at the time, of faculty members ignoring women students, that never happened.
No, whatever the opposite of ignore is, that's what I had.
Now, did Fritz know that you were German-born?
I think he did, because, and I no longer remember the name, at some point my father knew someone who had known Fritz, and I delivered that message, and so the connection was made.
Who were the teachers in the law school who meant most to you? You had great teachers in your first year, but over 3 years, who became the ones who were your mentors?
Well, easy is Grant Gilmore. I was very fortunate to be able to take 3 different courses from him, each more of a joy than its predecessor. Grant was not an easy person to get to know intellectually. I don't mean socially, but intellectually. So that the first one was commercial law, and because I had done well in the course subsequently, people wanted to borrow my notes. And they found to their dismay that the notes were question mark, yes, crossed out, no, crossed out, yes. It was just exhilarating.
And you remained a friend of his throughout all of his life.
That's right.
And also Fritz Kessler.
Yes.
Well, very different
and
people.
that relationship was not as intellectually intimate, if I can put it that way. We enjoyed each other. We were very good friends. But the intellectual spark that came from Grant was simply of a different order.
And his last public talk, the last thing he said, was at the graduation at UConn Law School, when Phil, your husband, was the dean there, and obviously you had something to do with that.
Yes. Yeah. He was just a remarkable mentor in every possible way. And there again, I had no sense that it was different because I was a woman. of course, his wife was a professional psychiatrist,
Yeah.
so he had some experience with professional women at home, and maybe that helped.
Did you do any work in summers and when you were in law school?
I worked for a grant one summer and discovered even that great men have footnotes that do not match text. But that's true of the Corbin casebook also, Corbin treatise. And one summer I worked with Ralph Brown on his book on, essentially on the loyalty oath, but I can't remember the right title.
Oh, the one that won the prize for the best administrative law book in its time.
That's right.
So you worked for faculty members both summers.
Yes.
There were no jobs? Or that's a lead question, I shouldn't ask it.
Of course there were no jobs. And they might have been jobs outside of New Haven, but by that time Bob and I were married. He was in medical school. As you well know, there is no thing except a very short summer break. So going out of town just wouldn't have been feasible.
And when you finished law school, when did you decide to clerk first?
I think I must have heard about that sometime in my third year, that there were clerkships, what they did, what they were all about. And I was vaguely interested in pursuing that. And then I got a call from Charles Clark.
No, he called you.
He called me. And I learned that he characteristically took the top-ranking student in the first year class, in the third year class, who was not going off to the Supreme Court. Supreme Court clerkships at that point were not available. That I did know.
Mm-hmm.
So I guess I maybe I'd had an interview with John Frank, not John, the other Frank, the legal
Jerome Frank.
Jerome Frank, thank you. Because a couple of years afterwards, when I first joined the faculty, there was one of those great faculty picnics in which Jerry, having had perhaps a little bit more martinis than he should have had, denounced me for not having clerked for him.
Oh, and you didn't even know that you had really applied to it. Well, he and Charlie Clark did not get along terribly well, and so the rivalry in getting the best clerks must have spilled over.
One of my Swarthmore friends ended up clerking for Frank. It was not a good clerkship. He was so eager himself to express a cornucopia of ideas that were in his head that law clerks only did the search work in the library.
Yeah.
Whereas with Judge Clark, the first day I set foot in the office, he assigned me to try to draft opinion in a case involving freight forwarders. Yeah, you can imagine how much I knew, and gave me no clue as to where he was coming down.
Mm-hmm.
And that was such a at the beginning a frightening experience, but once you learn how to do that, it was really a gift for life.
Do you know who suggested you to him?
No.
Just, he was, of course, close enough to the faculty so that it could have been.
Yeah, but I think he really did go by statistics if he could.
Mm-hmm.
So Elsa Wolf, I think, was our registrar at that point.
Yes.
And she undoubtedly was willing to answer his questions.
As to who was where in the class. And had he had any women clerks before?
Yes, that was not the first. That was nice.
Yes.
Yeah.
For once you were not.
That's right. And the only point that, as I now recall, where gender entered into it at all was, as you know personally well, Court sat in New York, and he lived in Hamden. It had been the tradition for his law clerk to carry his briefcase.
Oh.
He couldn't see himself asking me to carry his briefcase, and I didn't know enough to volunteer, and I suppose I might not have anyway. So we worked that one out. We took different trains.
I see. Did you, if you hadn't gotten the clerkship, had you any idea of what you were going to do directly after school?
Well, Bob had one more year of medical school, so I was going to have to be in the greater New Haven area. well, I suppose I would have looked for a job. At that point, I still didn't fully appreciate how difficult getting a job was going to be. At that point, I had no other job interviews, and that reality really didn't dawn on me until the next year.
I think the only major firm in New Haven at the time which had a woman working there was Gumbart, Corbin, Tyler, and Cooper. Mary Manchester, I believe, was a partner by then, but she had been made a partner much later because it couldn't happen until some person had left
the firm. Yeah.
But that was the only one.
Yes.
Yeah.
In many ways, I sometimes think I have succeeded by ignorance. It didn't occur to me that I was going to have a problem having graduated at the head of my Yale Law School class. I mean, just lots of letters of recommendation from anybody and everybody. I was too immature, really, to see what the real world was. And then as I think back on it, it never occurred to me to talk to lawyers in my way to going to law school. It never occurred to me to sort of inquire about what the profession was like. I just knew this was I was going to do whatever way it was going to go. I did think that I wanted to be a practicing lawyer. I had no aspirations at that point other than to do some hands-on experience. That's what my father loved. That's the stories he told me about his practice in Germany were all about problem solving in the most specific ways. So I really had no idea what I was going to do.
But then, in your year of clerkship, you went from there to California in a sort of semi-teaching associateship position.
Yes, essentially teaching research and writing in moot court, and then the second half of the year essentially being a research assistant to various faculty.
How did that happen?
Robert, my husband, had an internship at California, and that's where he wanted to go. That's where he was matched to go. You know about the matching system for internships. So we took off to California.
So that in many ways, your early decisions about law school, and the clerkship in New Haven and then California were moved by your husband.
Well, they were very conventional. There's another way of putting it. I had my unconventional corners, but basically I was very conventional.
And then after a year, you came right back to Yale in 1956 as an assistant professor.
That's so.
The youngest of all the people who came in that year, I believe.
Yes. Harry, I think, was just a year older, maybe, but not much older. He was the next child in the in the ranking.
How did that happen?
Much of it is not known to me. What is known and will be known to you is that the fratricide among the faculty had been alive and well in the years before, so that there were 10 vacancies, which I think was probably a record number of vacancies, particularly considering the size of the faculty at that point. Huge. And I gather there was a deal made, which was essentially to be translated as, I won't kill your candidate if you don't kill mine, which had been known to happen
in faculties.
And our beloved faculty as well. And so Adam Yarmolinsky, I am told, I've never heard this is all grapevine stuff, and hearsay, since we know is not inherently reliable, was engaged to put together a package of 10 candidates. Maybe they were more originally, but to put together a finite package. And my understanding is that the governing board voted for the package. You know, most of the package, it's an odd way of putting it, most of the people who were within the package came to New Haven for interviews. In those days, when air travel was not what it is today, I gather that the faculty decided there was no point getting me back from California.
We
paying
know
my
who she is because she was here recently.
That's right. And I think Charlie Clark was also an enthusiastic supporter. It was not going to be much they were going to learn. On the other hand, I was duly grateful in retrospect because you and I know what those interviews can be like, and I don't know whether that would have been congenial or not.
But did you have a sense that the package included you for gender reasons or much more for political who the backers were?
Oh, I'm sure it was the latter. The thought of having a woman on every committee and so forth really didn't come to consciousness until a good deal later.
Yeah.
So I was duly grateful to have a job. At that time, I had had my interviews in San Francisco, which absolutely parallel interviews that were had by Sandra Day O'Connor with her Los Angeles firm and Ruth Ginsburg, and with some of her interviews in which people said, "My, you have wonderful credentials. What an excellent record. Love to hire you, but I don't think the clients would understand, and thank you and goodbye."
So that was your first real sign when you were in California and starting to look for a practicing job. That
things were not going to be as easy as I had
Things were not
expected.
going to be easy as you expected. And then out of the blue came this offer from...
Yeah, Ralph Sharp Brown was an important force in that, and he was, I think at that time, a more important force in the faculty than perhaps he came to be later. And he kept running. I originally wrote him and asked him which of the New Haven firms might be useful to apply to, or whether there were other opportunities in the New Haven area, because it was clear we were coming back here for the residency. Give me some names, essentially, to write to. And he wrote back the first time and said, hold off for a little while. Maybe we can find a job here for you as a research associate. In my youth, I was sometimes arrogant. I hope I've at least diminished that capacity since then. I wrote back and said, I don't want to be a research assistant.
I'm doing that now.
In fact, I'm doing that now. I want to practice. I want to get my hands wet and doing it and solving problems. I hope I wrote it more politely than that. And then he wrote back and said, well, maybe we can do something better. And then very shortly thereafter, I got the telegram from Gene Rastow offering me this princely salary of $7,000, which I was absolutely thrilled to accept.
3 years later, I was offered a salary of $10,000. So that...
No, the numbers were certainly within the ballpark.
Yeah. But
having a job, at that point I began to recognize that this would be a wonderful job. I think the faculty, when they hired me, didn't know that I was married, did think it was likely that Bob and I would have children. And I think the unspoken assumption was, well, let's see how it works out. Not likely to be an appointment for more than 2 or 3 years.
Mm-hmm.
I was on my side perfectly prepared to say, if teaching did not turn out to be my métier, that I would find something else to do. So I think we all went into it with expectations that were finite. Much more so, I think, than for
and
others.
Bob, at that point, had gotten
he had a residency
in New Haven. But there, were you still following him, or
Sure.
was it...
I don't know how things would have worked out in California. We both liked California a lot. He'd gone to junior college there. We loved hiking in the Sierras. There was a lot to keep us in California. But, I was not in a position to evaluate residencies in psychiatry. And if he thought that was a place to go, New Haven, that was a family decision in which I had a very minor role. I didn't know enough. Wasn't sure that one could really find out enough anyway, but if the best hunch is that New Haven is the best place to be, that's what we were going to do.
But at that time, at Yale Law School, it was the first time that quite a few people from Harvard were appointed. People like Charlie Clark and Grant were a little bit on the outs as to what had happened in the last bloodletting. Ralph Brown was a kind of mediator between them, so that the idea of having a young, bright Charlie Clark clerk fit in.
Yeah, must have had some appeal.
Well, how did you decide what to teach?
It was very easy. The dean said, "You're going to teach such and such," and I said, "Yes, sir."
That was the way
that's how
it
my
was.
career unfolded. So that the first time I had a small group in contracts, which was wonderful. A small group is a wonderful institution for new law students, and I think even a better institution for new young faculty. It was just a very interesting way to relate to people and bring out their strength, and at the same time begin to learn the field myself. That was fun. Second term, the dean said, "You're going to teach commercial law and you're going to teach family law." And I said, "Yes, sir." That was not so successful. The commercial law class started out with something like 50 students. Within 2 weeks, it was down to 25 students. And Jack Tate, I guess his associate dean was his title, factotum for many things, called me in and he said, "Ellen, there's something you're not doing right." So I acknowledged he was probably making an accurate observation. But what I learned out of that experience is that I couldn't teach commercial law as if I were Grant Gilmore. That I had to find my own voice, and contracts, that wasn't so much of a problem in a small group, but in a larger class, I really had to be better tuned into giving some shape and structure to the class, and to help people who were in there for lots of different reasons to relate to the materials more effectively. I didn't succeed very well in that term, but I think I learned a lot from that experience.
But one has to develop one's own voice, and when one starts out teaching, one tends to imitate other people, and
sometimes it works.
Sometimes it works, and sometimes it doesn't.
Yes.
Yeah.
The other course that I taught that spring was family law, which at that point was really no intellectual challenge at all. And, that's a field that has changed so dramatically over the years. As it turned out, I also became pregnant, and just give Gene Rostow enormous credit. I thought I had better go see him before I blossomed out in maternity clothes. I was sure that everybody was oblivious until that point. But on the other hand, I made a courtesy call. And I wasn't at all sure what that conversation was going to look like. I mean, it was at least quite possible to me, relating back to my California experience with my interviews, that he would say, "How wonderful you and Bob will certainly enjoy your children. Thank you and goodbye." He didn't say that. Instead, what he said was, "What do you think you want to do?" Which was, given 1957, absolutely extraordinary. So I
His
said,
generosity and breadth is something which has been forgotten, but should not be.
that is right. He was very comfortable with himself during those years. And people who managed to achieve that degree of self-assuredness, it seems to me someone have less difficulty reaching out to others. At any rate, I said to him I really would like very much, since David was going to be born in August, to have a lighter teaching load in the fall, and I would make it up in the spring and do whatever he needed me to do then. And he said, "That's fine."
So you dropped family law and...
Forever.
Forever. Had you thought that they'd given you family law because that was something that women were supposed to teach, or was it just that commercial law...
It was the course that nobody wanted to teach.
So it was
I
like
was the
commercial
junior.
law, the junior. Property, when Bob Stevens and I came on, the same thing. You
That's
will
right.
teach this. And,
And, you know, I don't think there's anything wrong with that.
Mm-hmm.
The super specialization so early on in my teaching career would not have been an asset.
Yeah.
I had no expertise in anything, so it isn't as if something was going to be wasted in that process. So it seemed to me to be a perfectly responsible and useful way to go at it. If he'd asked me at the beginning, what would you like to teach, I would not have had a ready answer.
Mm-hmm.
I really wouldn't have known.
You had married during your clerkship?
No, Bob and I got married. Bob and I were sophomore classmates, and we got married after the year after the first year at law school in his cadaver.
I see. And then you were married, and you had how many children?
3.
3 children, who came at about what distance from each other?
The 2 boys are 3 years apart, and then Julie was another 5 years.
Mm-hmm.
By the time Julie was born, I was a full professor and entitled to a term of leave.
Yes.
Didn't have that pleasure earlier.
When the boys were born, you didn't have rights to leave. You had to negotiate for a lighter teaching, though.
But, you know, that's, as negotiations go, that's not a terrible burden.
Mm-hmm.
I don't know, it would be the same, I would suppose, if someone had had a relative who was desperately ill and needed nursing care. And the fact that I had a somewhat different role in producing babies than the rest of the faculty was really not a central issue.
How about
at that point?
At that point.
Became a central issue later.
Yeah, I want to ask you about that because that's was Bob supportive of your career at this time? Or?
I mean, that's the one thing that Swarthmore, I think, taught all of us, and that was entirely egalitarian.
Mm-hmm.
And you know, there were some times when we didn't see each other much when he was on surgical call. And indeed, when I was in law school still, and I was on the journal for a little while, Dick Juviller was my editor, and he liked to edit from 3 until 5 in the morning. And by the time I got back to our Quonset hut, Bob was off for his clinical years, so we overlapped, but some days not for very long.
Where were you living when you came back on the faculty?
We lived for the first summer at Grant Gilmore's house, which was very kind of him. And then we got a garden apartment overlooking the Rose Garden in Hamden, at the foot of East Rock.
About 10 minutes drive in?
Yes.
Yeah.
It was very comfortable for both
and
of us.
when your first 2 children were born, was Bob helpful around the house?
Yes, he was terrific. And he loved the children and was and is a terrific father.
So that in that respect, he was
blessed.
much more like men say they are today.
Oh, yes, no, that's absolutely right, and an important observation, because if he hadn't been helpful, it would have been difficult. But I also had the great help that is also not so frequent. An extraordinary woman named Dora Harris came to us 3 weeks after David was born, and stayed until Julie was 15. So an incredibly long period of time. And she became my children's third parent. And then she did not live in, but in the mornings, I would tell her what had gone on at night, and then in the afternoon when I came back, she would report on what had happened.
Do you think that your relationship with her and your hiring her was in part a product of being European, and so that kind of arrangement was something that you were more comfortable with maybe than with American?
That's a very good thought, and I think there's a lot in that. Lots of people at that point had baby nurses, but they didn't stay for more than 3 weeks.
Mm-hmm.
And that's an interesting thought. When David was imminent, Bob's thought first was that we would find some house or some precursor of what is today called daycare. And I said, nothing doing.
Yeah.
But I never thought through why it was absolutely clear to me that the answer was nothing doing.
Good. I think we can take a break. An hour is
Good
up,
idea.
And
Splendid. Thank you.
good, good. When Ellen, how long were you married to Bob?
25 years.
25 years. And then you broke up.
And we broke up. It was a marriage that was, for both of us, I think, very rewarding for many years. And then at the end, it wasn't so rewarding anymore. We decided to part company as graciously and as painlessly as we knew how to make it.
By then, your children were grown.
David, my oldest, was at college. Jim was a year away from college. And Julie was a young teenager.
Mm-hmm. And were you on the faculty at that point, or were you already a judge?
No, I was on the faculty, but on the verge of not being on the faculty, because the divorce proceedings were finalized in November or December, and sometime in that, I guess at the end of November, I had a visit from Jay Jackson, who was Governor Ella Grasso's emissary and lawyer and intimate advisor. A very nice man. And my instant assumption was there's another commission on which they need a woman.
Mm-hmm.
That was certainly a kind of conversation that I had had with numbers of people over the years. And at that point, I was really inclined to say no, because I thought I had given it the office. So I was utterly astonished when Jay came with the suggestion that Ella Grasso might nominate me and would see this through. I consulted with Harry about it.
Oh, Harry Wellington.
Harry Wellington, who was then dean. He said to me, well, do you have a great book that you want to write right now? Then say no. If not, what you ought to think about is to ask the governor whether she has a serious commitment to seeing this through, because there are bound to be some roadblocks. And unless she's really firmly in your corner, this is likely not to work out. Which was very sound advice. So when I went back to Jay Jackson, I pointed all this out. I didn't say I don't have a great book in me, but although that was accurate too. I then accepted the confirmation process. It was not easy for lots of reasons. Here I was, not a native of Connecticut. Here I was, not a practicing lawyer. And here I was, having never been a trial court judge. There were other things that slipped my mind, and of course I was a woman. Ella Grasso came to this because there had been an article written in the Yukon Law Journal, Law Review, suggesting that if she didn't do something out of rank, that there was not going to be on the state Supreme Court either a minority person or a woman until well into the current century. So she had some incentive. She had a second incentive, which was that she was just a little too late to get Judge Ellen Burns. Mm-hmm. Jimmy Carter, President of the United States, got to Ellen Burns before Ella Grasso could get to her, and so that was a done deal. I mean, it's a little facetious to say one Ellen is as good as the other, but it is the case that over many years when the other Ellen was presiding over the district court and I was presiding over the Supreme Court, we could get each other's mail. And she was listed as having opened courthouse, and I was listed as having been overturned by the Second Circuit. And fortunately, we are very good friends, and we both thought it was hilarious. But it was a part of the oddity of the times. There could be two women judges named Ellen. And it didn't compute.
It didn't. Was there? I want to come back to the judgeship and the fact that it wasn't only that you were a woman that made it unusual, but that it was a break in the seniority system which had reigned for years and that many people had been troubled by. So I want to come back to that.
Okay.
But then you were unmarried for how many years?
Well, technically, a little bit more than 2, but in fact, when Bob and I separated, we separated for good, so that was in 76. Philip and I were married in 79.
So that essentially throughout all of your career you've been married.
Yes.
That's
it's
an
the conventional me.
and because
and I have to say, it's obvious, I think, to both of us that my family is very important to me.
Mm-hmm.
My children are enormously important to me. And my relationship first with Robert and then with Philip have been enormously important to me. I get so much sustenance and so much loving support from family that you just don't get anywhere else.
But there's something odd about the suggestion, more than odd, I think it's profoundly sexist, that the suggestion that women, if they have careers, are not supposed to be married, but men, if they have careers, can perfectly well, and indeed are expected in some ways, to be married. And so I've always been troubled.
Yeah, we still have a lot of growing up to do in this area. But it was clear to me my first months on the court how much the justices and their wives interacted in various social occasions. I met Philip, seriously met him. We had occasional conversations at the every 4-year ball for the governor's inauguration. Mm-hmm. This is a huge undertaking. And my then Chief Justice said to me, "You've got to go?" I said, "No, you can do without me. I'll just be a fifth wheel in effect." "No, you got to go and you got to find an escort." And Philip was then dean of the law school. And I was
so
a new
an appropriate escort in terms of rank, protocol, and
that's right. And it was, I was very comfortable with the thought that he would not misunderstand why he was being asked. I'm interested in getting to know him better, but that was it was a ceremonial function.
Yeah.
And from there on, our relationship blossomed. But I say I guess all I want to really say is I'm a great believer in family. I think family is important.
And you've become quite involved with his children, and he's become involved with yours.
That's right. So we have when we were celebrating his 80th birthday in September last year, we had 20 family members there. Mm-hmm. It's just wonderful. And he and I share that important commitment to family.
Good. Now, when you went to the law school as a faculty member, were there any other women teachers in the United States on law faculties?
Sawyer was there in some role, not, I think, ever a regular member of the faculty, but certainly there. And on the West Coast, there was Dorothy, I'm blocking on her last name, Nelson, mm-hmm. who was teaching, was dean at USC very early on, and then had a distinguished career. And my mentor at UC Berkeley was a woman named Barbara Armstrong, and she had been teaching there for many, many years. So there were some, but they weren't a great number.
In her book, Herma, or in an article, Herma Hill Kay describes the first 5 women law professors in teaching, and you are one of them. I don't think she says which came when. I noted at the time that about half were foreign-born, and I wondered if that was a chance or
Yeah, well, I talked about that once with Hannah Gray,
mm-hmm. Also
falling into
foreign-born.
our category. And I guess it was when he was still provost. And then before the difficulties of not becoming president had surfaced. But we both recognized that we had a very different kind of upbringing and very different expectations. And I think the expectation principally that we would succeed. Not that we had to succeed, but that we would succeed.
Yes. A deep feeling that it would happen.
That's right. And so I think that's a common link among many of us.
Mm-hmm. Now, there was a woman who was on the faculty of a Yale Law School in the 1930s who was an anthropologist, I believe, who worked with Underhill Moore. So that technically you were not the first woman on the faculty. She wasn't a lawyer. Did that ever come up when you were on the faculty? Was that not a non-issue?
It was a non-issue.
Mm-hmm.
First or second was a non-issue. My tenure decision was not a non-issue.
Yeah, I'd like to turn to that because 10 people came as juniors, several people came as seniors, but 10 people came as juniors in 1956.
That is
and
right.
9 of them were promoted over a 3-year period, but they were voted at the same time. You were not.
That's right.
Why was that?
I expect people will have different explanations depending where they're coming from. I thought it was surely because of my gender. By that time it was clear that I was going to be tested differently and was going to have to have a different record in order to achieve tenure. And Jean Mostow was very clear about that. And I went into and expressed my dismay. That's really, Jean was a terrific dean because you could talk to him about things that were not comfortable, and he didn't get uptight about that, and that was a great resource. And Jean, in effect, said to me, "You're right, you're being treated differently. I will make research assistance available to you if you need some time off to do your writing. That's easy to arrange. But this is, in effect," he said, "this is the world you live in."
Mm-hmm.
I think what irritated me the most was that at least among the group of 9 there was one who never put pen to paper at all.
Yes.
Neither then or later. And so the mystique that they had all already done it was clearly not so.
The excuse at the time was that you had not yet written a major article, while many of them, say Alexander Bickel, had written books and things of that sort.
Absolutely.
But in fact, there were 2 people who had written very little, and one hadn't written at all. Brilliant people, but then so were you.
Yeah, that was a real comeuppance. And then when I talked to other people about it, I talked to Eli Clark, and he said, "Just hang in there. Start out writing some small things like book reviews. Book reviews are handy," he said, "for the bibliography. But mainly the thing to do is to hang in there, and it will happen." And I had essentially the same conversation, although not quite so graphic, with Grant Gilmore, who said, "I think it's unfair. Not much you can do about that. Nothing that I can do about it. But what we will have to do is, I'll be happy to be helpful in what you write and how you go about doing it." So indeed, what came to be the Commercial Transactions casebook was originally Gilmore and Peters.
I see.
And I had done, I'm going to say 90% of the work, but I really valued him as a co-author. A, because of all the things I had learned from him, and B, I thought if you were going to go to the marketplace, my name didn't have any currency, and his did. But as it was coming to an end, he finally said, "Now, I really haven't done the work. glad you've done it. I like it a lot. It's yours. So in that process, he really helped me.
He continued to be the closest mentor and intellectual figure.
That's right.
One always has a senior faculty member.
That's right. And he did it very graciously, very low-key, happy to discuss ideas anytime. I remember the casebook has some real property materials in it, which for commercial law casebook, it was unheard of. I'd had a conversation with Quentin Johnston when I was putting it together about analogies for warranties and real property and in goods. And he said there is no such thing except for warranty of title. But that didn't, you know, I was stubborn, and sometimes fortunately stubborn. I just didn't think that would be right. And indeed, within a few years, the New York decision came down saying that the row house in Levittown is not very different than the Cadillac, and there's no reason why
it became a part of the canon to do what.
Yeah. So, I think I had a conversation. I'm not absolutely positive, but I have a dim recollection of having talked to Grant about that. Does it make sense to explore warranty as a generic phenomenon that it appears in different segments of the private law, or should I really stick closer to? And he said, well, yeah, go for it. That's not the expression of the day, but
no, nor one that Grant would have particularly used, but the sense would have been very clear.
That's right. That's right.
The two who did not write, one wrote an article finally, the other, as you say, never wrote, were considerably older. They were among the oldest of that group of 10. Was that given as an explanation at the time?
Nobody really tried to explain it to me. Gene tried to be helpful as dean, but I don't think anybody ever thought of saying the reason why we make this distinction is
this.
But that was left for me to infer.
It was just not said. On the other hand, do I understand you to say that you had the sense that if you did write things of a certain sort, that the likelihood or the prospect was that you would get tenure, or was that also in doubt?
That was more ambivalent, I would say, than that. I think the writing at the law school was more eclectic in the 1950s than it came to be later. And I had, in fact, published a minor piece before, but it was not in the field I was going to pursue. But it was clear that I could leave then and there, or I could try to do the writing. But whether the writing would be acceptable was an issue, as I gather it was at the meeting that voted my tenure.
At that time, you had written the roadmap
and the casebook.
And the casebook, so that in terms of quantity, for that time, that was much, more than needed to be met by. Now things are different in the amounts that people write, but at that time.
But even then, casebooks were not regarded as serious, and the fact that this was taking a different angle of vision was really not of great significance. So it came down to the roadmap, and the roadmap has had its admirers then and now. I still run into young people, not so young anymore, who say they got through the bar examination by reading the roadmap. But it was precisely that aspect that made a lot of people on the faculty edgy. They thought it was too practitioner-oriented, that it was not sufficiently adventuresome, too grounded in a particular text. So it was not a given even then.
Now some people, I was there, and so some people said it was too male. Did you have a feeling in writing it that you were trying to be sure that you wrote according to a standard, to a stereotype?
No, that one would not have occurred to me because I wouldn't have known how.
Yeah.
I mean, that's an odd configuration to put to this manuscript.
Now, that was a very difficult time.
That was a very difficult time, and I would certainly have had to leave if that had not happened. It was not so long before that the absences that led to the 10 vacancies were a result of a lot of people having been denied tenure. So, and I knew about that.
So unlike other law schools, failure to get tenure at the Yale Law School was a real possibility.
That's right, and a not infrequent occurrence.
A not infrequent occurrence. Did you, what was the period just when you knew that you were up for tenure? Were you nervous? Were you upset?
It was a complicated period because it was also the time when Grant Gilmore was getting ready to go to Chicago because of his unhappiness about some of the issues that Morris McDougall had raised. And this was an issue of principle for him, and issues of principle were not fundamentally undiscussable, and I don't think I would have tried to discuss it with him anyway. So much my senior, so much my mentor, it would not have occurred to me to say, "You sure you want to do this?"
Well, he ultimately decided he didn't and came back. Bless it.
That's right. That fall, my tenure was voted in the spring, but that fall we had what was called the Children's Crusade to visit with Grant and say institutionally we needed him, we wanted him, and please to stay for us. Bob Bork was part of that group.
Bork and you were all, John Simon.
Yes. So we had a lovely visit. Nothing came of it, except that I do think at some point it became clear to Grant that if he announced his leaving for Chicago before the tenure vote for my appointment came up, that it would not succeed. And so he did me the great personal favor of staying around for that and then going off to Chicago.
Yeah.
But I do not believe that was an accident. I am very conscious about faculty politics. Had lived enough of it in the French department and then at the law school, so that he was very sensitive to the need for him to be there, which I think illustrates an accurate perception.
Yes. Now, did you get any sense of the opposition, or whether there was opposition afterwards? Did people come and tell you? People came and told me that they had voted against me because I was too young or something, and I didn't want to know, but they came.
Yes, they came to me too.
How did you deal with them afterwards?
Depended a little bit about whether thereafter we were able to have a more cordial relationship. And I, to the best of my ability, it seemed to me it was information I shouldn't have had, information that one should bury in the back of one's head as deeply as one could possibly manage it. It was not, the faculty was always a leaky sieve, but on this particular issue, one would have thought there would have been some consensus.
Yes. I was, as I say, I was shocked when and people came up to me and said that. And I've tried to forget it, but I remember perfectly well.
Yep,
once you were promoted, was that the end of that, or did you feel that that sense of a different level of testing continued?
Well, it certainly continued over salary. And at some point I went to one of the deans who was a successor to Dean Rostow, and said I was prepared to go and have a lawsuit if necessary. My salary was so discrepant. I was teaching a full load, I was doing my job, I was continuing to write, and I thought it was really outrageous. It took a lot to gear up to have that conversation, and the outplay was A, I got a substantial raise, and B, that dean respected me in the way he hadn't before. And that was an important lesson, I think, that I had not sufficiently internalized, that at Yale as elsewhere. Yeah. If you have a problem, you go talk to the person who can fix it, and you do it in a very straightforward and but unequivocal way, and things happen.
He sort of thought that he could get away with it, and it wasn't and nobody was going to say something, but
That's
when he was confronted, he knew that he was wrong.
That's right. Took a while to ferret out all of this because, as you know, there's great secrecy about salaries. And that, at least in my years on the faculty, was strictly enforced. I really did not know.
That still is. It's one of the few things which we're able to be, who knows why, but...
it's a sound policy.
And it was one thing in which the dean did take advantage. I learned at some point that my salary was much lower than someone else's because of a chance, and I had less hesitancy in having that conversation
Right.
because, of course, I wasn't a woman. Now, after that was set, in terms of position in teaching, how did that go? Were you up?
After that, I became a senior member of the faculty. One way of putting it is that nobody noticed that I was a woman anymore. I was just another faculty member, for better or for worse. Sometimes one, sometimes the other. But gender really played no role in it at all.
So you became chair of the appointments committee at about the time that it would have been standard for you to become that. And,
that's right. And I had a chair, and that was all.
And you were the first woman to be a full professor, but also to have a named chair, and it was a very distinguished chair as well.
That's right.
Who was the dean? Because that's something between the dean and
yes.
and the president and the faculty.
Yeah, that's a good question. Might have been Harry, or
Do you remember the year that you became self-made professor?
No. Might have been Harry. Who preceded Harry? That was Abe.
It was either Abe or Harry.
It might have been Abe. Not sure.
Yeah, but it was about that time, and that would have been just about the right time in terms of years and everything else.
And I certainly had achieved success in the classroom. I enjoyed it. The students enjoyed it. I found, in your words, my voice. I loved the teaching. Did enough writing to get by.
And you were teaching primarily commercial law and contracts. That had become your field, and you were the dominant figure in it, especially with Grant having gone to Chicago during his Babylonian exile.
That's right.
You were the figure there. So in a way, he did you a favor by being away at that point as well.
That's absolutely right. What I missed was having someone to bounce ideas off. And you know, in any faculty, that's one of the important, I think, essential roles that faculty play for each other. And that wasn't there.
You were quite close to Fritz Kessler at the time, but never in an intellectual...
That's right. We were close friends, and except I learned after a while never to accept a ride home. He was such a terrible driver.
Yes.
One took one's life in the hand, and I thought about my children. I thought, no.
I got lost coming and going from the funeral due to my incredible stupidity.
Yes. A lovely human being. I think intellectually we were not quite on the same wavelength because he was in many ways much more philosophical about contract law, and I was really interested in problem solving.
Yes. And in that, Grant was the perfect foil because he was interested in problem solving, loved them, but then always went to a meta level from that rather than coming from a meta level down.
That's exactly right.
And that's characterized your work and your view of law in general.
Absolutely. That's right. So I mean, by the time I left Yale to go to the court, since that was the time when my first marriage was breaking up, I might have gone someplace else to teach at least for a year, just to get out of New Haven. And I did indeed have a visiting offer from Harvard, which I was going to take, which I'd accepted. And I had no sense of how that was going to work out, but I knew by that time I could manage large classes. which is still, I think, one of the essential factors in doing well as a faculty member at Harvard. I was, perfectly prepared to see it through.
Yes. And then at this point, you get visited by
Jay
Governor
Jackson.
Grasso's assistant,
Yes.
and this gets thrown at you. Had you ever thought about being a judge before?
Not one day of my life. I mean, one of the aftermaths which amused me no end was when I was finally confirmed. I ran into the Democratic Party chairman in Hamden, someplace with him. Of course, I didn't know, but by that time my picture had been painted, so he knew me. And he said to me, "How could you possibly go ahead and do that without getting my okay first?" That was politics as usual.
That was politics as usual. And did you talk? You talked with Harry. Did you talk with other members of the faculty?
If so, I have no recollection, which makes me think it was probably very casual. Ella Grasso wanted it to be kept confidential until she announced it, and that was a little later in December. And knowing the faculty as you and I do, keeping confidence is not always on the cards. People don't mean to, but it's the conversational habit.
It's the habit of the argument, the conversation, and things come out. You didn't write or speak to Grant, who was in Chicago at the time.
That would have been an interesting thing to do. I think pretty sure I wrote him after the nomination.
What was his reaction when you wrote him, or did he have no reaction at all in that strangely Gilmorian way of just...
I don't think I ever heard back. A few years later, I sent him a copy of an opinion that I'd written. It was unpublished, by then published, on the right of a party who is in breach of contract to recover damages on some theory. And he wrote me back a long and interesting letter, and he said, theoretically, you make a very strong argument, but on the other hand, it was wonderful. It was wonderful.
It was almost coming back to the conversation.
That's right.
What was the reaction of colleagues and friends around the university? By then, you had been on many university committees. You were a figure in Yale generally, as well as the law school. What was the reaction?
I don't recall hearing much. Certainly I was not called by the then president, which would have been Kingman, to suggest that I should stay. Benign neglect was most of my interaction with the university,
yes,
except when I chaired committees.
Yeah. I think that's most of our experience.
And there's a lot to be said in favor of that.
And of course, in the law school, there was a feeling of pride. I mean, this was something that had not happened since Simeon Baldwin. But
That's right. I'd gone to the state court.
A member of the law faculty had gone to the Connecticut Supreme Court.
That's right. The route to the federal court was much more open.
Was much more open. But this, to the state court, was something, and Simeon Baldwin was the great figure in the history of the law faculty.
That's right.
So that there was tremendous pride, and you continued on the faculty. Did you teach?
I taught commercial law until I became Chief Justice. Every spring, as I recall.
How was that arrangement made? Just Harry asked you?
Yes. We talked about it on some occasion. I said I'd like to do that. I'd like to keep my teaching hand in. It got to be less and less successful. I learned, again, to my pain, that you can't be a good teacher if you're not going to be a scholar. And so I felt myself rehearsing old truths rather than searching for new ones. That's not good teaching. So was about ready to give it up anyway. Either that or invest a whole lot more energy in it, in keeping up with the field in depth. But when I became Chief Justice, it was really a non-issue. I mean, there was no way I could say, you know, Mondays between 4 and 6, there will be no crisis in the court system. And anyhow, I put in 8-hour weeks as it was, so it really was neither time, no energy, or really opportunity to continue to teach.
When did you move to Hartford?
In 1978, we stayed at my house in Hamden. I guess it was 1979, probably.
Mm-hmm. So before you became Chief Justice, but not immediately on going on the court.
That's right.
Or just no. There was a little bit of a leeway.
That's right.
When you were commuting in that direction rather than in the other.
That's right. As Julie, who was the only one who was still living with me, got to be older and was more involved in after-school activities, we all know what that takes in terms of parental assistance and driving, and she was at Hopkins, and it was sometimes unpredictable when she would want to go home, when she wouldn't. It was the days before cell phones. The commuting was a hassle.
Yeah. That book on contract that Harry said, you have a great book in you, and that book has never been written. Have you any...
Oh, no. I may have misspoken. He asked me whether I had a book in me.
I see.
And my answer was not immediately.
Not immediately. Have you ever regretted not writing that book?
No, I've moved on to other things.
Mm-hmm.
I think I will try sometime to write a book on federalism that relates to the seminar I'm now teaching.
But the subject matter of what you want to write on
has entirely different
because of your
reflecting my experience.
Yeah.
That's right.
Again, coming from experience to meta rather than the reverse.
That's right.
Yeah.
I think you're putting it very well. I don't think the way my head operates that pure jurisprudence is my long suit. Yeah. I've gotten sufficiently well versed so I can read it, sometimes with more pleasure than others, but it doesn't call out to me as the thing that I should be doing.
What was it like being confirmed at a time when you were not just the first woman, but the first person in years and years to be taken out of a seniority, the last one having been, I guess, Baldwin,
yes, right.
Not Simeon, but Raymond,
that's right.
Who, after all, had been
everything.
Everything,
that's right.
Plus a relation to somebody who had been everything.
That's right. Well, again, I have to say, naivete saw me through some of it. It took a while for me to recognize that not only Arthur Healy, whom I displaced, was the highest on the seniority line, not only he was being displaced, but that every other Superior Court judge had marked his calendar, being able to figure out
when they would go and whether they would be young enough to get there rather than be over 70 so that they could not be appointed.
Right. So there were a whole lot of people who were not entirely thrilled with my appointment. Yeah. One of the things that made it more possible, not great, but more possible, was that Joseph Longo, who was then on the state Supreme Court, agreed to take senior status and retire early the summer after my appointment, not immediately after, but a year after. And it was promised to Arthur Healy that he would get that appointment.
So that everything moved up a bit.
A bit. At least he moved up, and I think he's a wonderful man and deeply admired. A family with 8 or 9 kids. A person who really had the affection and the esteem of just about everybody in the judicial community. He was in fact taken care of.
Yeah.
And I think that managed to defuse at least some of the hostility. So, and I give great credit to Joe Longo for having been generous enough to make that happen.
What was it like to be a judge, never having tried a case? I don't know if you'd even consulted on cases.
I did some consultation, but never at the trial
you
level.
hadn't gone into a courtroom, really.
Never.
You hadn't argued a case in the
Of course not.
So that for you, your first experience in a court, like for me, was when you became an appellate judge.
You know, this sounds incredibly arrogant, and I don't mean it that way, but it was surprisingly an easy transition. The dialogue in the classroom, if it goes well, has at least some of the features of a dialogue that you have with counsel. Obviously, you can't dominate the scene, since there are other people who would like to be heard. But I was fortunate in the fact that John Speziale was not yet chief judge, but he had really inaugurated the notion that the court would ask questions. So I came into a scene in which whatever else was wrong with me, at least I wasn't starting to ask questions in the way I like to do right off the bat as the new girl in town. On the other hand, for years, lawyers addressed me as sir, even when I was Chief Justice.
They would address you as sir.
Every once in a while, in later years, I would say, who? But that was really not a good thing to do, because all it did was derail them entirely, and that was not the reason for the oral argument.
On the court, was there a feeling about having a woman justice? You were the first woman on the Supreme Court of Connecticut. Were there women judges in the lower courts?
There was Billy DuPont, who was in the trial court. That's when we had no intermediate appellate court.
Yes.
So there were maybe 10 women judges in the Superior Court. My court was enormously professional. In that way, much more professional than I thought than the faculty. This was it. I was going to be there. Whether they liked it or not, it would be much better for the court if we all got along. And the then Chief Justice was John Cotter. Was very clear about that. Very clear that he wanted to have no special attention paid to me. Mm-hmm. It worked out just fine.
How about the fact that you didn't have trial court experience? Was that something that you felt in argument, that people gave you a feeling, oh well, you didn't?
You
there
can't
are some things
empathize.
you don't know.
Yeah. I perhaps was too insensitive to notice. Mm-hmm. I did a fair amount of reading trying to figure out where things were coming from in the trial court. In every opinion that I've ever written, I've looked very carefully at the transcript. And most of the time I've read the whole transcript to get a sense of what's really going on at trial. And then there were the brethren, who were perfectly happy to educate me. Mm-hmm. And it was a surprisingly smooth transition, given the handicaps.
Now, do you think that they were surprised by the fact that you were a scholar who came from facts to theory rather than the other way around, so that it sort of violated their stereotype of the academic?
I'm not sure they had a stereotype of the academic. But that's not where they were coming from.
That's not where they were deciding cases, you were deciding cases.
And I fairly soon established the fact that I could write reasonably well, and that I could write interesting in the court with significant dispatch. I kept turning out
some early opinions in commercial law contracts, which are always complex fields, and where your brethren felt or quickly that you knew this and you could help them in a way.
That's right. No, And Chief Justice Cotter was very good in assigning me some of those cases, but not all of them. But that would have been a bad idea.
Yes.
I think a specialization on a Supreme Court, I think, is really a very poor way to run an important institution. So I mostly made a nuisance of myself by saying at oral argument to counsel, isn't this a problem, a contract that's governed by the UCC? In which case they would say, well, maybe. Never had the thought crossed their minds.
Mm-hmm.
So the bar was pretty provincial about the code. And then I did something else with the code, which was really, it was very important to my thinking. At Yale, the casebook compared warranties across the fields. And I thought the contracts principles that were in Article 2 of the code at least could be translated and have an outreach effect on other areas of the law. And we did that. And that was a very different idea for people.
And that started happening when you were an associate justice.
Yes.
And the court followed you in that direction.
That's
and realized that you were the leader in that area if the follower of their experiences and greater knowledge in some other area.
That's fine. Exactly right. But the other thing that has happened since then was that the court really accepted that philosophy and has in many years, for many years now, used the same principle for non-UCC statutes. So that we do a lot of talking about cases with counsel, if they're up to it, but certainly among ourselves, to try to create a common law statutory network.
Which, of course, was something that I care about, but is also back to Grant Gilmore, for whom the integration of statutes and common law was a part of
That's
what
right.
he taught us without ever being that
Putting it that way.
Putting it that way.
That is so true. So this was all very much ingrained in me. I was actually surprised that the court went along so smoothly.
Mm-hmm.
The first case in which I did it was, of all things, a land mortgage case. And the question was whether this was I don't have all the details straight, but it was a second mortgage, and the question was whether a very high interest rate was appropriate. And it was clear the lender had just skirted the various
usury.
The usury statutes, because it was a second mortgage, and then you obviously have to have a wider playing field. I didn't have any doubts about that, but the particular interest rate that he had chosen seemed to me outlandish. And I couldn't figure out a way to say that it violated any existing statute.
Mm-hmm.
So we imported unconscionability into land finance. And in years later, I became very good friends with a trial judge whose judgment was reversed on this entirely unforeseen basis, and I think he's now forgiven me, but it came as a rude shock to the trial.
Yes.
But that's an opportunity to think through common law and statutory interactions, intermeshing, interweaving, is a unique opportunity for state courts because we have so much flexibility in the common law system.
And does the fact that you taught contracts as well as commercial law, is that partly behind that you had the experience both of the common law and the statute?
It's an interesting idea. I'd never thought about it that way. It certainly seemed very congenial to me. And then, of course, a miracle happened. That is, you were able to find statutes on a computer. Because until then, to locate whether in a particular other statute there was similar language was a nightmare.
Yes.
And that experience I had working for Charles Clark, because the freight forwarder's case involved a statute on which, on the point at issue, which I've forgotten, had never been decided. But I found another federal statute that had exactly the same language, and it had been blessed with interpretation, and so I borrowed from
So
one
that
to the
you
other.
could do that, and years later, with computers, you started doing that, and your typing skill came into play, of course,
Oh, yes, of
immediately
course.
with a computer, because
Right.
you didn't have to do a double learn.
That's right. So many parts of my life came together on the court, and that's why
What
I
have
was
you
so
found
happy.
the greatest fun of being an appellate judge?
Trying to write an opinion that is absolutely on target, which has no sentence that is superfluous, but reaches all of the points that are seriously at issue. It's an art form of its own.
Yes.
And I find it a very exciting art form. I really respond to it.
Have you ever been frustrated by the limits that are put on a judge? Now, the limits on a Supreme Court justice in a state Supreme Court are less than the limits on a Court of Appeals judge, which is, after all, the most constrained court,
Yes.
largely because of other panels that bind us. But still, a judge is not a professor.
That's right.
Does that do you like that, or does it frustrate you?
I remember the conversations when I was still at Yale about Jerry Frank and his so-called opinions, which were clearly law review articles. And I remember the hostility that people had to that.
Mm-hmm.
And that was a useful memory. I very rarely indulged myself that way.
Yes.
And whenever I did, I was afterwards sorry. That was still in my growing up years.
But did you find
it's
that
a different art form. For a problem solver, that was fine. Sometimes it's frustrating because there are statutes that are not unconstitutional, but you wish you could find a way to strike down. The death penalty is one of them. I could not find a way to think of the statute being unconstitutional, even though my private views were quite different. That was a very hard case to write. I really wanted to persuade myself 105% that I was right about my legal judgment. And it was not congenial, not comfortable, but it was our first death penalty case, and I was the Chief Justice. It was clear to me that I had to do it.
Was that the opinion that you're least happy with
Yes.
in one level?
That's right. It was certainly a case in which, well, one way of putting it, there's a lot to be said on both sides. But I have a dilemma, and I expect that you encounter it too. Once you've made the hard call, do you write the opinion even-handed and then the final paragraphs, but on balance?
Mm-hmm.
Or do you write the opinion to support where painstakingly you have come out? I think I used to write them more balanced than I do now. That is, in time I've come to see that, for me at least, it works better to acknowledge, put in text what the arguments are that I'm not going to accept. But I certainly write the opinion with an agenda to support the bottom line.
Yes. Because that's the nature of a judicial opinion.
That's right. And that's, I think, what distinguishes it most emphatically from what I think of as scholarship.
Yeah. When did you first dissent?
I think it was about, it must have been the fall or the winter of the first year after I was on the court. There was a case involving the Dram Shop Act and whether or not who would be responsible if someone got killed because he was driving while drunk on the civil side. There wasn't much dissenting on my court at that point. And that was part of John Carter's philosophy. It wasn't good to have too many dissents. Obviously, if you felt strongly, you had to. But unless you felt very strongly, he thought it was a bad idea in terms of building the jurisprudence of the state.
Yeah.
There were certainly cases which came out unanimously that I wrote, in which one of the judges, whom I love and admired deeply, came right afterwards. He said, "You know that I've signed up But I'm not at all sure you were right about that.
No, you do. You go along. There are many cases where to dissent is wrong, and to write a concurring opinion even more so.
That's right. I mean, John Newman once said to me something which I thought was very wise, as he is in many ways, which is a dissent may call attention to something that you would like to soon bury, so that you can distinguish the case you don't like the next time.
Yes. What's the opinion you're most proud of, or opinions that
I think at the end of the day it has to be Chef against O'Neill.
Yeah.
It has to be. In some ways I allowed myself something I very rarely allow myself to do, which is empathize with the feelings of the people who were coming to us, and not just with the statistics or the findings of fact. And Harry Hammer's findings of fact were not bad. But my immigrant experience kept coming back to me. These were, whether they were majority or minority, these were people who were being excluded from opportunity.
These were outsiders. You had been an outsider, and you knew, maybe in a way other justices did not, what that meant.
I think that's right. It certainly made me write the opinion the way I did. I was also, even though it hasn't borne fruit yet, I was also firmly persuaded that the only way to make this opinion work in the life of the state was not to create the remedy then and there. You were kind enough afterwards to send me some articles about people who've talked about under-enforced remedies of one kind or another. It seemed to me all the experience in the federal courts had been imposing a solution from the outside was not a success story. No matter how well intentioned and how well planned and how many hearings there had been, it just didn't work very well. So it seemed to me important to write an opinion in which there would be, the court would set the outside limits and direct that something had to be done, but that the people who had to live with it daily would have the important voices in deciding how to shape this agenda. And to my astonishment, I must say, I thought this opinion would not be welcomed by anybody in government. And John Rowland had the strength to see that this was an invitation for him to look good.
Yeah. It also was a statement by the court of certain principles which said things to people, even if then politics as usual would attenuate them. But the statement that this is what our law is about is one of the functions that the Supreme Court has.
That's right.
And that brings me to that particular role of the Supreme Court in federalism and in protecting constitutional rights, apart from that of the Supreme Court and the federal courts of the United States. You've taken a lead in that. How did you get into that?
That's an interesting question. I guess many of us who were interested in this area were inspired by Brennan and his article encouraging state courts to, in effect, to grow up and to take responsibility. So I began to read about state constitution and to write a little bit about state constitution. That was an area where really my writing reinforced my judicial proclivity, let's put it this way. And I began to see that we had an opportunity to do something very useful with the document that's, after all, our organic document, of which many provisions have yet to be enforced. Although I think if the federal courts shut down on some of these important social issues, the right to access, which is constitutional in state courts, will have a revival.
Yes.
You know, it seemed to me that we were less in competition than we could learn from each other. And learning from each other meant that we could pay attention to history, which was often different. Connecticut has a very rich history starting in 1616. That's not true for some of the western states. And so we did have a foundation that was embedded too many layers down, but nonetheless was part of the understanding of the Connecticut system. Aided a lot by Wesley Horton, who was, as a lawyer, very interested in pursuing this topic, and who began to explore it in a lot of contexts, and people learned from him and chose to go onward. Doesn't always work, shouldn't always work.
No.
But I did learn also from Justice O'Connor that when we were going to go on state law, we should put in the Michigan and long phrase to make sure that it was very clear that even though we might cite some federal authorities,
deciding state law and not giving them a chance then to take it and say they might have been following the federal law.
That's right. And I thought their opinion was exactly on. If state courts are going to venture into new areas, they have to be prepared to take the heat. And to hide under ambiguity, I thought was just not an appropriate way for a court to behave. I think in the years before I came on the court too easily bought into federal structure of constitutional rights. It was, first of all, easy to do, didn't require much by way of research, but there was not much of a sense of independence by state law because, in part, one couldn't help overlook some of the experiences in some of the southern states and how state constitutional law had been used for very unpleasant objectives. And it really took the Deep South to get rid of those habits, at least to
before you could feel free in a way to say there are values in the state constitutions which we can use and experiment.
That's right. So I was fortunate that I began to travel this road after it was made possible by changes in the justices in the southern states. Some of them were clearly stronger than others, but again, the work of the federal court in the Fifth Circuit had some playoffs in that region, and I intuitively saw that as a two-way street, and we could perhaps begin to articulate some ideas. It might or might not be useful in the federal scene, but we could begin to go that way. There was one decision of the Second Circuit, never followed, in which your court said it would follow, in the case arising from Connecticut, it would follow Connecticut law of search and seizure.
Ah. I'll have to look that up. That's
I may be able to find it for you. Because I was interested in the two-way street. I think it's never been cited again.
Do you think that there is in today's society that there's a difference between women judges and men judges?
Question I'm often asked. I tend to think
it's here
not.
on this list.
Okay. Others have asked me too. I think there's more difference between us as individuals. I've always thought so. My identity at Yale was sort of an order of importance: family, Yale, classes, and then woman.
Yeah.
And that's really been the order of my life.
When you became Chief Justice, were there any difficulties of the sort as when you became an Associate Justice?
Well, there were some, because the next in line was, again, Arthur Healy. And there was some feeling that he'd been passed over once. This was his time. He was the senior judge, senior person in the judicial branch as a whole, in terms of length of service, from when he'd started in the trial courts. I was the senior judge in terms of length of service on the Supreme Court. Governor O'Neill clearly had a choice. What made it easier is that Arthur and I knew each other and admired each other.
And by then you had become friends in a way that when your original appointment
We wouldn't. And I must say, we were also infinitely assisted by our good spouses. Arthur's wife and my husband saw to it that the four of us sat together at public functions. And to make it as easy as possible for all of us to continue to work together, whatever was the outcome. And indeed, Francis Healy, after it was all over, we were having a conversation somewhere, said, you know, if it couldn't be Arthur, I'm so glad it was you. That was what, you know,
That's
and I
lovely.
would have said exactly the same thing. And so it was fortunate that, and I give John Cotter as Chief Justice a lot of credit, that in the interim years we had worked together very harmoniously, lots of support for each other, and we recognized each other's strengths and weaknesses, but in a not intimate personal friendship, but in a very real professional friendship.
When you became Chief Justice, that really was the first administrative job that you had had in your whole career. How did you take to that?
Well, that's the question that my husband asked me. And
He having been dean.
He having been dean and having had a distinguished career on Wall Street and run a Fortune 500 company, I mean, he had a lot of administrative experience. All the committee work that I did at Yale was not lacking in building some administrative know-how, in learning how to organize small groups of people to think through what their aspirations were and what on this particular agenda they wanted to achieve, to recognize when my preferences were not necessarily their preferences, and to work for something that we could all live with. It's not by any means the same, but the capacity to listen to other people, which I think administratively is the one thing you can't do without, had been at least somewhat nurtured in those other circumstances.
You found it easy.
After the first year and a half.
Yes.
I mean, there was just so much to learn. The next Wednesday you have to be there and to slowly build your priorities. I was very blessed with the fact that just before I came to be nominated for that position, my predecessor, John Speziali, who was an absolutely fantastically good administrator, had appointed the chief court administrator as a judge who basically runs the system from the trial court, but who reports to the Chief Justice. Aaron Ment and I worked together very smoothly. He learned that I do read everything that came across my desk, which I take it was a surprise. That predecessors had been known as to sign off. I just congenitally need to know. And that I was a fast study and that I would raise questions. And there was very little...
Being quick was helpful to you. Being quick
That's right.
was helpful to you.
That's right. Being able to work through a lot of stuff, get a sense of where the action was, then try to ask whether or not there were other... Mostly my role was, I thought, to ask further questions. I don't know that I ever turned something back entirely, but I often asked for further information or some other angle that needed to be explored. So because I didn't think it would be useful to be the Chief Justice who makes all the daily decisions. Couldn't do that, didn't want to do that, but I did want staff to understand that I would read carefully the proposals that came to me, and to the best of my ability would cast a very critical eye on over what they had done.
Your colleagues have described you as really a great leader of the court, both colleagues now and those who have left the court. I just talked with one who is a federal judge now and who described those as great days. Did you feel yourself as a leader?
Well, not at the outset, of course. At the outset, I just wanted to keep the judicial branch from making any terrible errors. That's the nightmare. I really did not want to appear on the front page of the Hartford Courant. I think I saw my role, as I grew into it, as seeing the possibilities of what could be accomplished administratively that you couldn't do judicially. That there were ways of encouraging staff, there were ways of teaching new judges, that there were issues about gender and racial fairness that you could really only get at by doing it systemically throughout the system. That was a very exciting discovery, that it was possible to do these, to reach out in that way, beyond the particular needs of particular judges, and to help the system to grow, and to grow in a way that would be as responsible as we knew how to be. And that was the most rewarding part of being chief.
We haven't talked about lawyers and litigants and their relationship to you, except for the ones who called you sir. That hasn't come up. Is that because it really was not a terribly
it was not
significant
an
issue?
The dialogue in the appellate court, as you know, is very stylized.
Mm-hmm.
Even if lawyers were annoyed at my question, it was not really very politic of them to say much about that. In time, the lawyers who appeared before us recognized that there's even more than under John Speciale. This was going to be a court where there were going to be lots and lots of questions, and that prepared speeches might be allowed to go on for 3 minutes max, and that we were there to engage in a dialogue. And I did a fair amount of speaking around the state, explaining why I thought that was appropriate. I'm sure I didn't get unanimous agreement on that. But it seems to me it's the court's time. It's the last time we have to ask questions of somebody who's knowledgeable, who knows, at least in theory, knows every page of the record and has thought very hard about the questions, much more intensively than any of us will have in the short time that we prepare for oral argument.
Basically, you viewed oral argument as a chance for somebody who had read all their briefs, had all their arguments, to ask them about the weak spots in their case. That's what you've been described as.
That's exactly right. Or the discrepancies between the briefs, which was in early days sometimes startling. But that's really what I worked out with my law clerks. Mm-hmm. I always read all the cases before oral argument, and then we would sit down and work them over, and the agenda being, what questions should I ask? And so that pre-argument dialogue with the clerks
sets you up for...
Yes, that's right. And they were very good. They often suggested that I ask questions which would not have occurred to me. Mm-hmm. I sometimes ask questions that would not have occurred to them. But so the pre-argument conference with the clerks was, to me, an immeasurable benefit when I got out on the bench.
Your relationship with your clerks was, I know, was wonderful because I know many of them. Did it have some aspects of you as teacher still, or
sure. I had by the time I had worked for 2 or 3 of them, I had an outline. Mm-hmm. And I said, there are lots of good ways in which you can write opinions. And there's certainly no one model, but there's a me model. There's a Peters model. And when you draft opinions in these chambers, for these chambers, this is by and large the style that I would like you to observe. It's not an iron rule. Some cases don't follow it into a pattern very easily, but most will.
You used your clerks a lot.
A great deal. In the fall, there was a lot of teaching, but certainly by the time January came around, we were all sharing writing first drafts. Mm-hmm. I did a lot of editing. They, fortunately for me, did a lot of editing on my draft opinions. But they were an invaluable resource. I'm sure you find the same. Particularly as I got further distant from the academy, one of the frustrations is not to be able to call up somebody and yell.
Yes.
And so
In
I have
the
an
old days,
administrative...
judges could do that, but it's ex parte and it's forbidden, and properly so.
That's right. Right. But I thought properly, yes. But if I call up somebody who's been teaching administrative law for 20 years and I say, I don't want an answer to anything specific, I'd just like you to give me a list of the 5 most interesting articles.
Well, that's all right, because the articles are part of the...
No, but you're not allowed to ask.
You're not allowed to ask.
Without copying.
The other side.
So I've never done it. And it was more urgent at the beginning, but it was really a no-no.
But the clerks, in a way, serve as...
That's right.
as
The clerks
intermediaries.
serve that purpose very well, and they bring new ideas and certainly new angles of vision on old ideas. And that's terrific. By and large, I've been blessed.
And a strong judge knows that everything that comes out of her chambers, his chambers, is going to be their own.
Of course.
A weak judge is more afraid of clerks in that sense.
Yeah, and some of them some of them go to either extreme, let's put
Yes,
that.
yes.
And that's, everybody has to find their own relationship with clerks. And my clerks, and I had a much more frequent set of conversations than I think was true of many of my colleagues.
Do you think being a woman has been a major part of your career, a minor part? Where does it fit in this?
You know, it fits almost the same way that being an immigrant fits.
Mm-hmm.
It's part of who I am. I wouldn't for a moment deny it, but it's not the top of the agenda.
It affects you in ways that
that are often not apparent to me.
Mm-hmm. Being a teacher, being an immigrant, having a particular background is there, but it isn't the dominant thing, or even a thing that you think about when you're...
That's right. I mean, the women, as you know, didn't start coming to law school significantly after you and I were tenured. And I used to have all the women to my house for potluck supper. That house on Grand Parkway could accommodate a lot of folks. And I was both delighted and unhappy when there were too many. We couldn't do that anymore.
Yes.
I mean, that's sort of the way I think about it. It's there, and yet it's certainly not as central to what I think I am and to what I think is important to me than many other things.
Do you ever think that your parents would be really pleased, as people who are immigrants, to have seen you carry out that tradition in that way?
My mom died too early to really see me as an adult. She died the year after I graduated from law school. But for my father, absolutely. There was the family line and the family tree, and
there it was.
Deeply embedded. And I thought he was delighted. And I think at some of them quite conscious how helpful he had always been. Mm-hmm. And not only in describing the profession with great joy, but in allowing me to make up my own mind, not pushing too hard. I never felt that I owed it to him to do this. I knew he would be delighted, but that's very different.
It's very different, very different. Well, it's been a great ride, and you've now retired as Chief Justice, and you're young and vital. What next?
Well, after my surgery, I didn't quite feel young and vital, and I'm not entirely there yet. I think I'm going to take a few years to do in a much low-key fashion what I have been doing, and then take stock. I really like writing opinions. It's not generically different on the Court of Appeals. I will have written 6 opinions by the time I go off for the summer. And they're not the same as the Supreme Court cases. On the other hand, I think I know enough about what's going on across the street that I can signal whether I think this is a case that they should take on cert.
Yes.
And I can do that with more authority, I think,
Than anyone else.
That's right.
Yeah.
And other cases that look at first blush as if they're interesting and really aren't, I'm quite consciously writing them to make clear this is not a case for you. So in that sense, I have a special role.
Well, there is that about an intermediate appellate court of signaling, Judge Posner in the Seventh Circuit and we disagree completely, or, well, there is some difference in other words, Supreme Court, take this one please, or this one lay off for a while, let it simmer more.
That's right. So that's an interesting part of my current experience.
And the book on federalism?
I have to sort of see how I feel. I'm going to teach the seminar in the fall at UConn, partially because I won't have the driving and I won't have a law clerk to drive me. But also, I think it will require me to be somewhat more organized beyond the large categories of what I need to do. And that was one of the very helpful comments I got from one of the young people in the seminar at Yale last fall. That they enjoyed it. We obviously enjoyed each other. It was a wonderful experience. That they would have welcomed having more of the questions raised ahead of time to give some more guidance and direction as to what it was they were reading. And I clearly need to do that. And UConn will be a very good place because it will drive me to do that. The seminar was one of those happy groups which just took off.
Yeah.
All you had to do is dump and something on the table, and you know
they do it. They
you know, as wonderful Yale seminars can be. Not always a success that way, but I just had just an extraordinarily good group of highly articulate and highly engaged students. So the rest is yet, the future is yet to come, I think.
One thing from the past that I neglected to ask you about was you were head of the Association of State Chief Justices.
Conference of Chief Justices.
Conference of Chief Justices. And that was, you were the first woman to be that. It was also a time when women were becoming Chief Justices. Did you view yourself in that role in a special way? How did that fit into the...
The only one who had preceded me was, of course, Rose Bird of California fame. And one
of
of
the association.
In the conference.
In the conference, yeah.
And my first encounters with what came to be the Brethren was people repeatedly asking me why she wasn't there, to which I didn't have a very good answer then or now. In the way the conference is set up, there are some committee meetings one day and then the more formal program for the next few days. In one of the committees, there was a judge from one of the southern states who said, "Now, what's your view, little lady in the back?" And the good outcome of that story was that afterwards we got to be very good friends. So as an initial obstacle, it was much more conspicuous than it had been at Yale or at the court in Hartford. But there were a lot of brokers. And these were people who were very highly successful political skills, most of them elected, of course, but beyond that, even if they were appointed, very deft. And they were able to build bridges with me and for me. Some of them became my great friends, and that's how I finally came to be the chief. But that was a milieu that was surprisingly egalitarian.
Have you been in particular touch with the two most proximate and also great Chief Justices, the Chief Judge in the case of Judith Kaye and Maggie Marshall, Chief Justice of Massachusetts? I mean, you were the first in this area, but now there are these two.
Maggie Marshall was, of course, once my student.
Yes, and as she told me, and I recently saw her.
Yeah. Judith Kaye and I became very successful colleagues. she really took on the state constitutional law issues, looking critically, but also, in many cases, happily at some of the things that we had done in the state system. New York is, of course, an incredibly difficult place to manage, and so I wouldn't want to even begin to think what her job is like on that level. But otherwise, we see problems a lot alike, and without having asked her, I don't think being a woman is the top agenda for Judith Kay either. Margaret Marshall, I think, is still feeling her way on the Supreme Court, the Supreme Judicial Court in Massachusetts. And when we last saw each other, she said she was going to come down and visit with me, talk about being Chief Justice, which I look forward to. There are now, the last CCJ conference that I went to, past chiefs are invited to come to any conference that they want to go to. I saw that I think at least a third of the chiefs are now women.
So the little lady in the back is no longer...
is no longer.
Just,
and in fact, I think women have moved up more quickly in the judiciary than they have in the academy, which is a matter of some interest.
Well, we've been talking for over 2 hours. Is there anything else that you'd like to tell me in kind of wrapping this up?
When I look back upon my life, I think about certainly the difficulties in my early years, which I was old enough to appreciate after a while. Appreciate is not the right word. To understand and to feel deeply about. That from those beginnings, I have had the incredible good fortune. Good fortune to get into a decent high school by somebody telling my parents. Good fortune of going to Swarthmore College because the Lord had 2 sons there. Good fortune of coming to Yale and finding it really a home away from home. And first as a student and then as a faculty member. And then to have this opportunity to do something extraordinary. I could not have imagined in my wildest dreams. Is something for which I can't even express my gratitude. It's such an overwhelming vote of confidence by this country in welcoming people who, at least at some time, were very different. And yet I know that with many of these remarkable experiences, I contributed to making them happen, but many other people contributed also. And sometimes there was the good fortune of being at the right time, at the right place. So I'm grateful. I think I've had just as wonderful a career in the law as I could expect, or hope for, or dream for.
Thank you. This is wonderful.